Mr. Epstein, you may proceed. Mr. Rosenberg, sorry. I wanted to give you a second chance to buy the cherry. Yes, you may proceed.
Make 3 copies of the Warren decision which I referred to and which Justice Ledwaba asked to be made available. I understand that counsel for the third respondent is in any event preparing a bundle of the authorities that were referred to, which will include the Warren case, but for the purposes of my reply, it would be convenient if justices have it before you. Justices, the point of departure for the purpose of the reply, given the suggestion that the applicant's case has changed significantly, and that significant change is in some way a pointer that the application represented some form of abuse of process. If I could refer you to the founding papers, Bundle A, page 10, paragraph 10, where
I think Mr. Rosenberg is bundle 1A.
Bundle 1A. Yes, it's not the record.
Yes.
Paragraph 10 of the founding affidavit, the...
What page?
Page 10, paragraph 10. The broad basis of the attack is set out, and you will see, Justices, that in the first instance it's based upon rationality, decision not rationally connected to the information before the information before the direct or the reasons given, and so it goes on. That's dealt with further in the second subparagraph. While public policy considerations may be relevant, there's an attack on the approach to the public policy considerations which were taken into account, and it's asserted that they don't come near to the level required in order to justify a stay, insufficient weight given to relevant considerations. And over the page, for the first time, the fourth attack is based upon the ulterior motive, the suggestion that it was an impulsive decision made under considerations of political pressure, perhaps. In paragraph 11.6 and page 13, emphasis is put upon the nature of the crime of corruption. It's not so much the merits there, it's the nature of the corruption charges. And in paragraph just let me find that, the allegation is made that, paragraph 13, page 14, the allegation is made that these attacks in the first place find a home in a Paja review, but equally the self-same attacks find a home under a rule of law rationality review. So there's never been a suggestion that the application as it was initially framed was somehow misconceived and had to undergo some form of reformulation in the course of these proceedings. The second point that bears emphasizing is that, as indicated in my opening address, a rationality attack, and I referred here in particular to the Similani decision, 2013 one, it's decision 6 in our bundle of authorities, as authority for that proposition, the point was made that a rationality attack, or the principle of rationality, involves not only substantive rationality, it involves procedural rationality. I made the point with reference to Similani, paragraph 39, that a failure to consider relevant factors can render a decision irrational. So it's not the case, as was remarked at some point in argument yesterday, that a failure to take into account material information is just a parja ground. It's not. And similarly, I made the point that a rationality, for a decision to be rational, it has to be taken in circumstances where the power is not misconstrued, the questions to be asked are not misconstrued, and linked to that I submitted, and that was also again with reference to Similani at paragraph 27, I made the point that there must be no misapprehension either as to the facts or the legal position. A decision made under a material misapprehension will not pass the rationality test. The requirement that a decision must be made based upon a proper appreciation of the facts and the law goes to a further point, and that is the suggestion that in these proceedings this court should, for some reason, be bound by the inferences that Mr. Hofmeyr chooses to draw from the recordings. And the suggestion was made that if those inferences are reasonable inferences, the court must somehow approach it as if it's a reviewing court considering the reasonableness of a decision, and it can't interfere, as it were, if Mr. Hofmeyr's inferences regarding the factual matrix could be said to be reasonable. That's not the approach or the proper test to be adopted to that aspect of the matter. The tapes and the content of those conversations form part of the relevant factual matrix relied upon by Mr. Masher to conclude that there had been misconduct. And this court must and can look at those tapes to see whether the facts are as Mr. Masher concluded they were. Was he perhaps making his decision on an apprehension of the facts, which was incorrect in any material way? As to the conduct of Mr. McCarthy, the point was made in the founding papers, paragraph 94, that to the extent Mr. McCarthy's conduct was established, it was to be strongly criticized. And that there can be no quibble with that proposition. All right-thinking people would agree with that. Political interference of any kind at any stage of a prosecution, no matter how insignificant, is strongly to be deprecated. But it doesn't detract from the fact that a clear-eyed analysis must be made of Mr. McCarthy's conduct. And as far as Mr. McCarthy's conduct is concerned, in this particular case, i.e., in relation to the contention of manipulation for political purposes of the timing of the service of the indictment, we would submit that the recordings, in fact, do not reveal quite such, as Mr. Hofmeyr said, nasty and awful picture. It's not to suggest that Mr. McCarthy in any way comes across as blameless, far from it. But what we do suggest is that if the case for the respondents is, as appears from Mr. Hofmeyr's affidavit, that this was not a decision of Mr. Masher or essentially the prosecuting team or the authority, but it was a decision, that is to say, the decision to delay the service of the indictment. This, Mr. Hofmeyr says, was a decision of Mr. Nguka, truly. Mr. Nguka was pulling the strings, and it was his decision which he managed to get implemented through his agent, Mr. McCarthy, acting at his behest. That's the extent, or perhaps the distance to which the NPA goes in its conclusion as to what these tapes reveal. And we merely make the submission that if you have regard to the conversations to which we've referred, particularly if you have regard to, as it were, the earmarked and most significant conversations which the NPA relies on, the conversation of the 7th of the 11th, the reference to the Business Day editorial, the conversation of the 26th of the 11th, where Mr. McCarthy says that up to now, and this is perhaps the high point of these conversations, up to now, he had effectively been going along with what was seen, what one infers was Mr. Nguka's preferred course to delay the service of the indictment, but there had been a strong reaction from the prosecution team, and that meant that, in fact, the indictment was going to get served. And Mr. Nguka, as we've indicated previously, accepted that. There was no pushback from him as the controller. The conversation just moved on. So we submit that the tapes, the transcripts, insofar as they bear upon the relevant conduct, are limited in their impact. But for the purpose of the argument, in fact, and we have accepted that for much of what we've submitted in our submissions, it can be accepted that Mr. McCarthy, for whatever improper reason, managed to persuade Mr. Mshe to delay the service of the indictment. Mr. Mshe himself says that, and if I could just get that reference, Mr. Mshe himself says, well, it's in the main answering affidavit as confirmed by Mr. Mshe. It's page 218, paragraph 166, where we get the following.
Which volume is that? Which volume?
Paragraph, volume 4, page 218, paragraph 166, where it said, and this was confirmed by Mr. Mshe, Hofmeyr states, he later learned that he, Mr. McCarthy, had successfully lobbied Mr. Mshe and persuaded him that it was necessary to delay the prosecution. And we know it may not have been all that difficult a job to persuade Mr. Mshe to delay the prosecution. We know that even if, according to Mr. Hofmeyr, no considerations other than a narrow view of proper prosecutorial considerations should be taken into account. We know that there was a school of thought that was of the view that given the potential instability that might be caused by service of the indictment before Polokwane, as a matter of sound practical management of the matter, it might be appropriate to serve it after Polokwane, so that a volatile situation was not made worse. Minister Mabandla, we know, was of that view, and quite frankly, one wouldn't be too quick to criticize the Minister of Justice's view in that circumstance as being an improper interference with the prosecutorial process. And one knows that Mr. Moshe spoke to the Minister on the night of the 5th of December 2007, and one knows that the next day he communicated a view that the service should be delayed, and that he was at pains to in fact say it was his view, not the minister's. It was his decision. Maybe Mr. McCarthy had also managed to strike that chord with Mr. Moshe, that there were practical and good reasons, bearing in mind the mood in the country, to delay, and that in the context of the matter as a whole, that delay was not significant in the service of the indictment, given, as I've indicated, the stage of readiness of the process in that matter. And I have referred, for example, to minutes of the earlier meetings where all the to-do items were particularized. We emphasized that if regard is had to what transpired at the meeting of the 1st of April 2009, that Mr. Moshe's decision seemed to be an impulsive one. It is clear that at that stage, Mr. Moshe was vacillating or moving towards a view that others may be implicated up to the President, whether it's Mr. Castrol's, the President, the Minister. But what one does know is that at that meeting he announced, contrary to what his position had been the previous day, the 31st and the 30th, he announced that he'd listened to the tapes, he was shocked, he was disappointed, and he had decided to withdraw the charges. We've emphasized that it's not at all apparent why the decision was so urgent. We've emphasized that that's particularly the case in circumstances where, if there was uncertainty as to the basis upon which any decision should be made, in other words, uncertainty as to the extent and nature of political interference, it made imminent good sense to investigate further and, in fact, to get responses from possibly implicated people. Not in the first instance so much as out of fairness to them, but that of course is a factor, but primarily in order to determine the proper facts upon which this crucial decision was to be made. We know that, as at the 1st of April, there was a timetable for the stay proceedings, the application to stay the proceedings. That appears at page 98, bundle 1A, not of the record of the papers in this matter. And we know that, in fact, according to that timetable, The third respondent was to deliver his application for the permanent stay on the 18th of May 2009, and the timetable followed. And it may, and it certainly has been one of the contentions put up on behalf of the applicant in the founding papers, that in these circumstances, given the nature of the decision, and given uncertainty as to the facts and conclusions to be drawn from it, it may well have been the appropriate course, in fact, to permit the matter to be dealt with judicially in the stay proceedings, particularly if regard is had to the question of public perception in the context of this decision. Because the public perception in the event of the prosecution being withdrawn by the director in these circumstances might very well be, as it has been suggested as a possibility from this bench, the public perception might be one which causes much greater damage to the institutional integrity of the NPA than would otherwise be the case. Withdrawing a case such as this at the 11th hour on this apparently rather narrow basis could, and we suggest, in fact, has done grave damage to the institutional integrity of the NPA in the minds of the properly informed members of the public. So, in those circumstances, we say it was an impulsive, emotional decision, a decision which we say by its very nature was an irrational decision. It wasn't reasoned at that stage at all. Reasons had to be put together. Those reasons we see in Annexure JS10. We don't have to go there at the moment. In fact, perhaps, Justices, you could go to Annexure JS10 in Bundle 1A at page 120. We have emphasized that on the face of it, the reasons make it absolutely plain that the reason for the decision was Mr. McCarthy's misconduct in relation to manipulating the timing of the service of the indictment, and that constituted, or that was, an affront to Mr. Mshe's sense of justice. He was outraged at that conduct. We referred earlier to a number of passages in the answering affidavit which reaffirms that Mr. McCarthy's conduct in this regard, the timing misconduct, was the reason for the decision. We made the point that on the basis of JICAMA, National Lotteries Board, and similar authorities, the default position is that the decision maker is not permitted to produce further and better reasons when the reasons which have originally been produced start under attack to become or to appear insufficient. Van Zyl is a case which was relied upon on behalf of the NPA in its supplementary note to suggest that that approach doesn't always find application. Van Zyl, of course, was a case where Rule 53 was not employed, where the decision maker had chosen not to give reasons and hadn't been asked to provide reasons at that stage, and then sought to expand or provide further reasons. In the matter we're dealing with here, this was a Rule 53 process that was followed. The decision maker was called upon to provide further reasons if so minded. It didn't do so as part of the Rule 53 record. It very clearly provided reasons in the press statement, detailed exposition of its reasons, and the National Prosecuting Authority quite properly accepted in its written submissions that this matter must be decided on the basis of the reasons produced in JS 10, and it accepted that to the extent that Mr. Hofmeier's affidavit travelled as it does far and wide beyond those reasons, this was to provide so-called context. What we have, however, in argument is an attempt to, as it were, place Brow's mole on the table. We know in the answering affidavit, not only was Brow's mole placed on the table, Mr. Celebi was placed on the table. Mr. Herinel was placed on the table. Alleged Mr. Nguka's involvement at a much earlier stage was placed on the table. Political involvement involving certain of the parties in this matter in two other unnamed sensitive matters was placed on the table. In argument, Brow's mole seemed to occupy attention. We don't understand on what basis Brow's mole can occupy the kind of prominence which the respondents have sought to give it. We know that Brow's mole, in a sense, was relatively old news. We know that the JSCI, the Joint Standing Committee on Intelligence's report, had come out in November 2007. We know that Mr. Piccoli had taken steps to discipline or rein in Mr. McCarthy or talk to Mr. McCarthy prior to September 2007. We don't know exactly what it was, but it was prior to Mr. Mshe taking over in the wake of Mr. Piccoli's suspension. We know that in June 2008, Mr. Mshe had sought ministerial intervention. So clearly, Brow's mole and Mr. McCarthy's role in Brow's mole was nothing new. More particularly, in the context of this matter, Brow's mole was not part of the reasons, or it didn't in any basis or way form a basis of Mr. Mshe's decision. The only mention that Brow's mole gets is in the concluding paragraphs of the Mr. Mshe statement, page 131 of B1, where after announcing his conclusion, for the reasons given, Mr. Mshe talks to the need for further investigation. And it's clear from that that Browse Mole is one of the aspects in which further investigation is going to be undertaken and is required in order to fully establish its relevance and what needs to be done. But it's equally clear, if one reads from what goes before, that Browse Mole and Mr. McCarthy's conduct in Browse Mole was not a reason for the decision to discontinue. The applicant has submitted that Mr. Masher concluded that Mr. McCarthy's conduct offends his sense of justice, and in those circumstances it followed that it was inappropriate to continue the prosecution, and for that reason, it's with great regret, says Mr. Masher, he has to say that he cannot see his way clear to go to court. As an officer of the court, I feel personally wronged and betrayed by this conduct, and it's neither possible nor desirable because of this conduct to continue. We've submitted that Mr. Masher failed to engage in the second leg of the inquiry, to balance the competing considerations. It's not sufficient merely to conclude that there was misconduct. Even serious misconduct, which profoundly outraged one. For example, in the Warren case that we've handed up, there was misconduct of the most serious kind. The commissioner, the judicial officer who heard the application for the stay, accepted that there was misconduct of an extremely serious kind, that in fact may be said to have satisfied the but-for test. But notwithstanding that egregious misconduct, and if one has regard to the speeches of the judges in Warren, one will see that each of them is at great pains to emphasize in the strongest language the unacceptable nature of the misconduct in question. However outrageous it was, it still had to be balanced. And if I could, in that context, remind the court that if one goes back to Latif, and Latif, of course, was the case centrally relied upon and referenced by Mr. Masher, and is the locus classicus, in a way, of the abuse of process doctrine which founded the decision. And at page 157 of the applicant's bundle of authorities, Lord Steyn says it's now necessary, and against the letter G on the left-hand page of 157 as one looks at it in landscape, it's now necessary to consider the legal framework in which the issue of abusive process must be considered. He makes the point that entrapment is not a defence under English law, and says this, however, is not the end of the matter. Given that S would probably not have committed the particular offence of which he was convicted, but for the conduct of H and the customs officers, which included criminal conduct, how should the matter be approached? And this is, of course, the question that should have occupied Mr. Masher's mind. This poses the perennial dilemma. 2 lines on. If the court always refuses to stay such proceedings, the perception will be that the court condones criminal conduct and malpractice by law enforcement agencies. That would undermine public confidence in the criminal justice system and bring it into disrepute. On the other hand, if the court were always to stay proceedings in such cases, it would incur the reproach that it's failing to protect the public from serious crime. The weaknesses of both extreme positions leave only one principled solution, and that's the balancing exercise. And it's a balancing between those extremes of, on the one hand, never staying and allowing a perception to arise that the means justify the end, and on the other side, mechanically staying, for example, when the but-for test is established, where there's entrapment or illegal renditions and so on, in those cases saying, well, that leads to, as it were, an almost invariable stay. So however strong one's disapproval is of the conduct, one must balance. And in that regard, it's also useful to have reference to the Maxwell decision again, not the Maxwell decision, the Warren case, which I've handed up, the decision of the Privy Council, where at paragraph 24 of that decision, Lord Dyson referred to a judgment of Lord Brown, who was sitting with him in this decision, in that matter as well, where Lord Brown said the courts would appear to have left the matter at a general level, requiring a determination to be made in a particular case whether the and I'm reading from paragraph 24, whether the continuation of the proceedings would compromise the moral integrity of the criminal justice system to an unacceptable degree. Implicitly, at least in this determination involves the balancing exercise that we've seen that Lord Steyn indicated had to be undertaken in Latif, taking into account factors such as the seriousness of any violation of the defendant's or even a third party's rights, whether the police have acted in bad faith or maliciously or with an improper motive, whether the misconduct was committed in circumstances of urgency, emergency or necessity, the availability or otherwise of a direct sanction against the person responsible for the misconduct, and the seriousness of the offence. And I may add there, in relation to another point made, it's not so much the merits of the case, it's the nature of the charge that was also particularly important, the seriousness of the offence. And I've emphasized with relation to the dicta which I quoted from Glenister in relation to the cancer of corruption, there could in this matter really have been no more serious set of charges that could have been brought or been under consideration than those encountered in the circumstances of this matter. Paragraph 25, Lord Dyson says the board considers this a useful summary. One final remark in this context is that Warren does indicate that insofar as the approach of the courts in the United Kingdom may hitherto have been to say where there was, as in the entrapment cases and as there were perhaps in the extradition rendition cases, clear examples of where the misconduct implicated the accused directly, but for the misconduct, the accused would never have been before the court. But for the misconduct, say in Maxwell's case, the accused would never have made the subsequent confessions which were subsequently sought to be relied on. Both Maxwell and Warren, as we understand it, were cases, in fact, where there was the but-for test or requirement was satisfied. But notwithstanding that, the courts said it doesn't automatically lead to a stay. There may be circumstances where even if there was a reprehensible entrapment resulting in the accused being charged with a particular crime, other factors may outweigh. So one has to still adopt a less hidebound approach, particularly in that context. What we would emphasize, however, is the converse. One must look at the converse. If there's no link, no connection, as it were, between the misconduct and the accused's position, in either a fair trial or in any other way, then for the most part we'd say it would have to be a very, very unusual situation for a stay to be granted of the prosecution in circumstances where the misconduct, the link between the misconduct and the prosecution is tenuous at best. But it remains an evaluation of all the considerations in the particular context of those polar extremes mentioned by Lord Steyn. Serious crimes must be seen to be prosecuted, but you don't want a situation, a perception to arise that any means are justified. Here, for example, we would suggest that one's not dealing with entrapment, with illegal rendition, or other conduct, which in a sense is going to be relied upon as a means to an end. It's essentially, as we've submitted, largely insignificant in the context of this prosecution. And counsel for the third respondent acknowledged as much, as far as we understand it, when he said, yes, the timing doesn't really make much difference in the prosecution, in the proceedings. Whether it was before or after the new year, or before or after Polokwane, doesn't really make much difference. What makes this conduct so significant was it was an attempt to, and it potentially might have, one can't necessarily go along with that, been conduct aimed at changing the political course of the country, and it may have had political consequences of that magnitude. Well, let's leave that description there. But it remains insignificant, or relatively insignificant, by the third respondent's own concession to the prosecution. And that's what's relevant. And before we leave Warren, if I could ask you, Justices, to turn to paragraph 83 of Lord Kerr's judgment, where he sets out certain of the principles that have emerged from recent jurisprudence regarding how the balancing process should be undertaken. The point that we want to emphasize is under subparagraph 5, where he says a stay should not be ordered for the purpose of punishing or disciplining prosecutorial or police misconduct. The point that he's making there is relevant because there was a submission made by counsel for the third respondent yesterday, and I refer to that as the put that in your pipe and smoke it submission, because that was how it was couched. It was said that really this decision was one which was saying to all prosecutors, This conduct must be addressed. It was essentially conduct, it was a statement of, as it were, using the stay or the question of discontinuation of the proceedings as a means, in a sense, of addressing or punishing the misconduct. And in circumstances where the misconduct bears little or no relation to, or is insignificantly related to the prosecution, then, as was said by Lord Dyson, you've got to look at appropriate means in the balancing up. You don't just look around and say, well, this provides a useful tool to deal with Mr. McCarthy, for example. If Mr. McCarthy's conduct was the problem, there may be other ways to deal with Mr. McCarthy. We have submitted that it's clear, both from the reasons and from Mr. Hofmeier's affidavit as confirmed by Mr. Maché, that no attempt was made to balance the various factors that I've drawn the court's attention to. There was no attempt, in truth, to, for example, have regard to the seriousness of the charges. No attempt to weigh up the question of the policy considerations of charging. No attempt to have regard, in fact, to any other means to deal with the misconduct. No attempt, in fact, to have any proper regard to whether this was an end justifying the means case, whether, in fact, like an entrapment or a rendition case, the misconduct itself had particular consequences and caused particular prejudice for the third respondent, for the prosecution, or for anybody else. Those factors didn't receive any attention in our submission because, in fact, stage 2 was not embarked on. And we say that that becomes equally clear if one has regard also to the answering affidavit filed by Mr. Hofmeier. Mr. Hofmeier dealt with the reasons for Mr. Maché's decision at paragraphs 12 to 49. I'm not going to ask the court to go there, but if you read through paragraphs 12 to 49 of that answer, one is struck by the complete absence of any account of any kind of evaluation of the kind of factors that are central to the second stage of the inquiry. And similarly, if one also looks at paragraph 486 of his affidavit, page 294, where he purports to deal with paragraph 10 of the founding affidavit, which sets out the various bases and components of the rationality attack, including the failure to address the policy considerations and the inquiry properly. Again, there's no attempt made to indicate how a proper evaluation was made. And we submitted and we repeat that if regard is had to the nature of the misconduct, if one regard is had to the seriousness of the crimes, the charges, if one has regard to the policy consideration that crimes of this magnitude must be seen to be prosecuted, as opposed to saying in certain circumstances, when there's been a situation where means clearly can't be seen to justify the end, In this case, as I indicated in my opening address, if anybody were to ask themselves why are these charges being withdrawn after all this time at the 11th hour for this reason, it makes no sense. And if anyone were to be asked, what should I do? Should the charges be withdrawn in these circumstances? We submit the answer is clear. It speaks for itself. That question has only one answer in our submission. The question of relief, we say that the relief as framed is appropriate. We've sought a setting aside of the decision, that the conduct must be declared, and the decision, i.e. the conduct in question, must be declared unlawful as it is required to be by Section 172 of the Constitution. We submit that, as was held by the SCA per Brunt JA in the Freedom Under Law case, it is inappropriate to put in place further relief directing and regulating what the National Prosecuting Authority must do, what further steps must be taken. That would be an inappropriate interference. At this stage, if we have a situation where a decision was made to withdraw the charges, virtually a day or two thereafter, a court recordal is made in the form of a court order recording that the NPA has withdrawn the charges. If the decision is set aside, of course, that order in the normal course would be overtaken by events, recording the decision which has now been set aside, and the further steps to be taken by the prosecuting authority in advancing the matter is essentially beyond what this court should busy itself with, and for that reason, just as in Luli, the supplementary relief is inappropriate in this matter. The relief that is sought provides the appropriate relief when a decision of this nature has been found to be unlawful. As regards the amicus's submissions, I'm not going...
Before you get there, Mr. Rosen, I don't quite follow your submission on the question of declaration of the legality question. Are you saying that the applicant still persists with the attack on 179? Is it still to be considered by this court?
The attack on 179 is no longer relevant to the extent that the National Prosecuting Authority, in its argument, has accepted that the decision in question was a corporate decision. It wasn't a decision, the decision to prosecute, that is. It wasn't a decision that was made solely by Mr. McCarthy, and that Mr. Mashere's decision to discontinue is properly to be construed as a review of Mr. McCarthy's decision, which would be circumstances in which 179 would apparently find proper application, and it was as a result of that in the answering papers it was said, well, in the first instance this wasn't a decision that was taken just by Mr. McCarthy. It was essentially a decision that was taken by Mr. Mashe, or at best, or alternatively, a corporate decision. And in those circumstances, if it is accepted by the National Prosecution